Yeah, dear colleagues, dear friends, it means a great pleasure and honor to me being invited to moderate the first panel discussion of today, touching upon cybersecurity, cyber insecurity, obviously a very urgent issue and at the same time a multi-dimensional topic. We already had the chance with General Starlinger to briefly address the interstate dimension of cybersecurity, which means cyber attack or attacks attributed to states, and the related and very interesting question, when does a cyber attack turn into an armed attack? That's not the topic of our panel. We'll focus on the internal dimension of cybersecurity, and that can be the protection of infrastructure against cybercrime, cyber attack, or terrorist attacks in particular, attributable to non-state actors. We also see a personal dimension, the protection of networks, applications, communication, and your personal data. Quite often discussions we have are directed against or concerning state interference and thereby bringing in a human rights and fundamental rights perspective. That is the personal dimension. And we also have a very interesting economic dimension. I tried to get the figures. There is an estimation that by 2026, we will spend $260 billion on cybersecurity. And I mean, the general brought up the question how to invest money wisely. Obviously, there is a very, very strong need to invest in cybersecurity. We have a wonderful panel of highly renowned experts, and I have the pleasure to introduce our first speaker and panelists, Magistra Johanna Schachner. She studied law at the University of Vienna and served as a university assistant at the Institute of Legal Philosophy. She afterwards worked for the Criminal Intelligence Office, and I learned it's not associated with intelligence as we use the term regularly, but Bundeskriminalamt. And now she is a legal expert working for the Federal Minister of Internal Affairs. She is also a renowned lecturer and speaker at several conferences, as well as the University of Vienna, touching in particular on topics related to current developments related to security and police law. So, Johanna Schachner, now the floor is yours. Thank you.
Thank you very much for the introduction, and thank you very much for the opportunity to speak on this topic that has pretty much been the main center focus of my work for the past 2 years. I will be focusing on the most specific topic of today's panel, I think. The other speakers will take a more holistic approach to the issue of cyber insecurity, but I will be focusing on the topic of lawful access to encrypted data by law enforcement, specifically in Austria. But first, I would like to give an overview of the challenges that are posed to law enforcement by the rising use of encryption. And then I would like to present possible legal solutions to these challenges, specifically focusing on the new regulations within the State Protection and Intelligence Service Act in Austria. Now, why do we need lawful access to encrypted data at all? We need it because terrorism, organized crime, and many, many other forms of crime all have something in common. They all leave digital traces, which is why, according to the latest Europol report on encryption, around 85% of criminal investigations nowadays rely on electronic evidence. And while a decade ago, the main issue for law enforcement was the availability of data, nowadays it is the accessibility of that data, because we see an increasing use of encryption, specifically when communicating electronically. According to this Europol report on encryption, messaging nowadays takes place about 97% through using end-to-end encryption, and only 3% of messages are sent through SMS or MMS. Now, end-to-end encryption, which ensures that only communicating partners can access their communication, is a robust security measure for the individual. Without a doubt, it can prevent data theft, unlawful eavesdropping, and many other forms of unlawful access to personal data. However, it can also create lawless digital spaces due to the inability of law enforcement to access this data. Now, this is why the Europol report on encryption stated that introducing legal frameworks for lawful access to data and the use of encrypted communications in judicial proceedings is paramount for achieving the right balance between privacy and security. Just to give you a quick overview of European regulations, European frameworks that regulate the access of law enforcement to encrypted data are very fragmented in the EU. However, generally, it can be said that most European countries do have some sort of framework regulating the access to encrypted data. However, they do take very different approaches. So, for example, France and the United Kingdom use an approach where they set out laws which compel service providers to either provide backdoors to the encrypted communication or to decrypt encrypted communication themselves and provide law enforcement with already decrypted communication. Whereas Germany specifically, and also the Netherlands, have taken a similar approach that Austria will take in the future by establishing the so-called source telecommunication surveillance, meaning that encrypted data is surveillanced at the source where it is still not encrypted or already decrypted. This means that a software is usually used to infiltrate the target device and to access the data before the encryption, usually using so-called zero-day vulnerabilities, which are vulnerabilities in an IT security system that are unknown to the developer. Now, Germany has a very broad approach to the surveillance of encrypted data, since it not only allows the source telecommunication, which we are now instituting in Austria, but furthermore, it allows the so-called online search, which is the possibility to access any locally stored data on a computer system. So not only ongoing communication, but also retrospective communication, any locally stored photos, any iCloud backups can be accessed by law enforcement in Germany. Now, looking at the EU, we of course know the EU has very limited legislative competence when it comes to internal affairs. However, the EU has already recognized the significant challenges that law enforcement is facing due to encryption, which is why the EU has, in its so-called Protect EU, in its current internal security strategy, set out two goals regarding encryption. First of all, by 2026, the Commission will present a technology roadmap which will consider different approaches to implement targeted lawful access to encrypted data. And by 2030, the EU wants to equip Europol with capacities to support the member states when it comes to decryption, seeing as decryption capacities, meaning softwares that can decrypt encrypted communication, are usually very expensive. They take up a lot of resources. So the EU is taking a centralizing approach to this issue. Now, what are the challenges to Austrian law enforcement specifically? First of all, I've already talked about the challenges that we're facing because we cannot monitor encrypted communication. This leads to the failings of a lot of criminal investigations and the possibility of not being able to prevent specifically terrorist attacks because we cannot access this crucial electronic evidence. However, it also leads to a significant dependency on the cooperation with foreign intelligence services, specifically the cooperation with the NSA and CIA and also the German Foreign Intelligence Service. Now, the dependency on matters of internal affairs on foreign entities is already highly problematic in itself, but there's also another problematic dimension to this topic, because when foreign intelligence services transmit data, they usually transmit it for intelligence purposes only, which means that the information may only be processed by another intelligence service. This leads to the problem that this electronic evidence that we receive from another state cannot be used in a court of law and cannot be used as electronic evidence, even though we have this information. And since our intelligence service lacks the abilities to reconstruct this information, criminal proceedings often fail due to this lack of electronic evidence. And the reason for this transmission for intelligence use only is usually because foreign intelligence services have one main goal. They always have to protect their source. They have to protect the investigative measures that were used to obtain this information. So Austria is behind specifically Germany when it comes to this. So we are very dependent on Germany for the access to this sort of electronic evidence right now. I just want to give a quick overview of the legal framework that the police operates on for anyone who's not familiar with it. There are two main acts that the Austrian police force operates on: the so-called Security Police Act, which comes into play when a concrete threat needs to be averted, and then the Code of Criminal Procedure, the SDPO, which later comes into play when a criminal offense has already been committed and needs to be investigated. And in the context of today's topic, the SNG, the State Protection and Intelligence Service Act, also has a very central role because it lays down the competences of the so-called Directorate for State Protection and Intelligence Service, which I'll come to in a minute. And it is the main act that governs the competences needed for intelligence gathering even before a concrete threat has been identified. Now, the directorate that I've been talking about consists of two entities: State Protection, which is responsible for the preventive protection against attacks by an individual endangering the Constitution, and then Intelligence Service, which is responsible for the so-called extended threat investigation, so it monitors potentially criminal groups who could be dangerous to the Constitution. Now, in the following, we will focus on state protection because state protection, as I've said, is responsible for the monitoring of individuals, and the surveillance of encrypted data is an investigative measure that is specifically tailored to the individual. Now, specifically the Austrian legal situation, I will be talking about the new attempt to implement surveillance of encrypted messages in Austria, but it was not the first attempt. Back in 2018, the so-called Federal Trojan was the first attempt to establish surveillance of encrypted messages within the Code of Criminal Procedures. Back then, the surveillance would have been limited to the investigation of crimes that were punishable by more than 5 years imprisonment, respectively 6 months imprisonment, if the owner of the to-be surveillanced device consented to the surveillance. There would have been an order of the prosecution necessary based on a judicial authorization, and it was planned to carry out the surveillance by infiltrating a targeted device with a software, like it is done in Germany, using zero-day vulnerabilities. And furthermore, it would have also been admissible to carry out house searches in order to gain access to the device and then put the software onto the device. We will be looking at the new Austrian regulation later, which does not allow that. The surveillance would have been strictly limited to ongoing communication, so there was never any attempt in Austria to establish the so-called online search that Germany also currently has. And furthermore, the surveillance would have continuously controlled by the legal protection officer of the Ministry of Justice. I did say a lot of should have and would have for the last slide because these regulations never entered into force because they were repealed by the Austrian Constitutional Court before they could enter into force. The Constitutional Court back then ruled that undercover surveillance of communication constitutes a serious infringement of the private sphere and is only permissible within very narrow limits and only for the prosecution of very significant crimes and the protection of very significant legal interests. The court back then decided that the regulations of the Code of Criminal Procedure did not meet these high standards and therefore were in violation of Article 8 of the European Convention of Human Rights, the right to respect for private and family life. And it mainly laid out 3 or 4 main arguments why the regulations violated Article 8. Mainly, the surveillance enabled comprehensive insights into the private life of a person and affected many uninvolved persons. So any Ist schon wieder da. We're back online. And seeing as this infringement of the personal sphere was so severe, it was not limited to the prevention of serious criminal offenses. Now, the court also doubted that the control of the surveillance was sufficiently effective by the legal protection officer, and last but not least, the court said that house searches for the reason of installing a software are not admissible, seeing as the individual never gains knowledge of the house search, which is not admissible within the Austrian legal system. Another selected Supreme Court judgment from Germany regarded the exploitation of IT vulnerabilities by a state. The German Federal Constitutional Court ruled in 2021 that Article 10 of the Basic Law, so the privacy of correspondence, does not only guarantee the individual a defensive right against state interference, but even lays out a duty to the state to protect the individual and IT infrastructure from third-party attacks, so from third parties gaining knowledge of private communication. And the court recognized that this leads to a severe conflict when the state, on the one hand, has a duty of protection of the infrastructure, and on the other hand, wants to use IT vulnerabilities to carry out surveillance for security purposes. However, the court said that this exploitation of IT vulnerabilities is not inherently incompatible with the state's duty of protection, but it has always got to be accompanied by a legal framework that sets out regulations or requirements that the law enforcement always has to assess, on the one hand, the risk of keeping an IT security vulnerability open, and on the other hand, the interest to use this vulnerability for surveillance purposes. I'm quickly going to touch on the new regulations in the State Protection and Intelligence Service Act in Austria, because this has been a topic of ongoing public discussion for at least the past 2 to 3 years. It has been a long-standing demand of the Directorate for State Protection and Intelligence Service to establish the possibility of the surveillance of encrypted communication, but these demands only became concrete in the autumn of 2023, so approximately 2 years ago, when an expert group was instituted in the Ministry of Interior to establish this surveillance investigative measure. Now, we took about a year to draft this law, and following that, we had to undergo not one, but 2 assessment procedures. The first one followed the prevented attacks on the Taylor Swift concert in summer of last year. So while we did not start drafting the law at this point, which has often been claimed within the media, it did allow us to go into assessment because the coalition reached an agreement because of the prevented attacks. And the second assessment took part only earlier this year, seeing as the current coalition could agree on putting the surveillance of encrypted data into their government program. Now, the main points of criticism and concern that we received during these assessment procedures could all be boiled down to these main points. First of all, specifically concerned individuals were concerned that we are trying to establish some sort of mass surveillance with this investigative measure, and that there is a high potential of misuse. Specifically, NGOs feared that there's a potential that members of the political opposition or journalists could be monitored using the surveillance software. Furthermore, it was often criticized that using IT vulnerabilities for the infiltration of the software could lead to a general destabilization of IT security in Austria. And furthermore, there were, from a technological point of view, quite a lot of doubts that there is such a software that can limit the surveillance only to certain applications, for example, WhatsApp or Telegram, without accessing the entire computer system and allowing a comprehensive insight into the entire computer system. And last but not least, it was often criticized that we did not guarantee the protection of professional confidentiality with the planned regulations. Now, I'm quickly going to touch on the key points of the new regulations that have been passed by the National Council only on the 9th of July of this year. Basically, we are introducing 2 new investigative measures in the State Protection and Intelligence Service Act. First of all, the surveillance of unencrypted messages and information, which is already part of the Code of Criminal Procedure, so it can already be used for the investigation of crimes that already took place, and now it can also be used for the prevention of serious crimes. This surveillance takes place in cooperation with the service providers, so there is no need for infiltration of a device. And the second and the truly new investigative measure is the surveillance of encrypted messages and information, which is only possible by the installation of a software on a monitored device, usually using zero-day vulnerabilities. Now, the substantive conditions for these investigative measures are fairly high. They are limited to the prevention of either espionage or attacks endangering the Constitution that are listed in the SNG, and which are punishable by at least 10 years imprisonment. So we're talking about very serious terrorist threats, or, for example, the participation as a member of a terrorist organization or terrorist financing. So only for the prevention of these crimes may surveillance be admissible. The surveillance also has to be the ultima ratio. So all other investigative measures within the SNG must have no prospect of success. The owner of the monitored device must be the individual who poses the constitutional threat. So we are not allowed to infiltrate the device of a communication partner of the targeted suspect. And the definition of messages and informations that we can in future surveil is very broad. It is analogous to the SCPO and pretty much encompasses any content of electronic communication, even the so-called machine-to-machine communication, so the autonomous communication between computer systems, which also includes, for example, automatic backups. And this measure is strictly limited to ongoing communication. There's no online search, only messages and informations that are being transmitted while the surveillance is active can be monitored by law enforcement. The legal requirements for the software. Now, I cannot, unfortunately, talk about the technological aspects of the software. That is all highly confidential, but I can talk about the legal requirements. First of all, the software has to be installed remotely. House searches are not admissible. The directorate never gains immediate access to the surveillance computer system to put the software on it. So the remote installation usually follows 2 steps. First of all, we have to identify the target device, specifically through undercover investigative measures or the use of so-called IMSI catchers. And in the second step, we have to install the software onto the program by using zero-day vulnerabilities. There are several methods by which this can be done. The most common ones are the so-called 0 or 1-click method, meaning that either a direct message is sent to the suspect, so he doesn't even have to click on anything. The malware is sent to him directly, and the 1-click method means that, for example, an undercover investigator who's part of a WhatsApp group where the target suspect is also part of sends a message containing a link, then the target clicks on the link and the malware is downloaded. Now, the software has to be able to limit the access to certain applications, meaning it has to be able to limit its access, for example, to WhatsApp, to Telegram, or whatever the judicial authorization may have laid out. This has often been confused in the public discussion surrounding this topic because it is true the software has to have direct access to the entire computer system for what we usually call a legal second. During this legal second, the software gains the administrative rights it needs for the surveillance. However, even before installation, the directorate has to program the software for this specific use, has to program it so that it only can access the certain applications that are laid out by the judicial authorization. So after it has gained administrative rights, it takes away its own rights to access the entire computer system and can then only access the communication platforms, and the directorate only receives messages from these communication applications. Now, the software has to be installed without causing any permanent damage to the device. It has to be removed after the surveillance, and every use of the software has to be protocoled, including how the software has been played onto the device, when it has been played onto the device, how the IT system has been identified, and this is a very crucial measure to prevent misuse. The formal conditions are quite substantial. First of all, before the first use of the surveillance, the legal protection officer of the Ministry of the Interior has 3 months to assess whether the software meets the technological and also the legal requirements. And we have to report to the Parliament, especially considering the costs of the software before the first use of the software. And before every single surveillance, the DSN, the Directorate, has to give the legal protection officer 3 days to issue a statement considering the necessity of the measure. After that, the Directorate has to apply for judicial authorization by the Senate of the Federal Administrative Court, which consists of 3 judges. Only in cases of imminent danger may the authorization also be issued by a single judge. And in this authorization by the court, it has to be laid out which applications can be accessed by the software and during which time, up to 3 months, the surveillance can take place. Now, the Directorate has to continuously assess the messages and delete any messages and informations that do not have a direct link to the supposed attack endangering the Constitution. And apart from that, the legal protection officer has an extensive control over the surveillance. He can access all the messages that are being processed. He can at any time demand the deletion of messages. And if he should have concerns regarding the proportionality of the measure, he has to request the revocation of the judicial authorization. And the legal protection officer also takes up provisional legal protection, meaning that he has any legal remedy that the surveillance person has after he gains knowledge of the investigative measure during the surveillance is still active. Then also additionally, there is a parliamentary control set out. The Directorate, or more so the Minister of the Interior, has to report to the Committee on Home Affairs if the cases of the surveillance of encrypted messages surpass 30 within a year. However, we are currently estimating that there is going to be a maximum of around 10 to 15 surveillances within 1 year. Yeah. I'm already on the last slide anyways. Thank you. Just shortly, there are several legal remedies for individuals whose messages were monitored. They are to be informed of the surveillance, and then they can, for example, appeal to the Supreme Administrative Court or the Data Protection Authority. And lastly, I would just like to touch on the fact that the provisions regarding the surveillance of unencrypted messages enter into force already with the 1st of October of 2025, whereas the surveillance of encrypted messages is still dependent on a notice of the Minister of the Interior that the technological requirements for the use of the surveillance software are fulfilled. And with that, I would like to thank you for your attention, and I'm very looking forward to this session.
Yeah, I'm having the pleasure of introducing the next speaker, Professor Dr. Markus Helfrich. He studied law, political science, and economics in Munich. He was head of the legal department of the Max Planck Institute since 1993. He is an advocate, and since 2010, he is professor of international business law at the University of Management and Technology. And now the floor is yours. Thank you.
So thank you very much. And by this opportunity, I would like to thank you for the kind invitation just to speak here, but not only speaking here, but listening to the marvelous and extremely interesting sessions and statements we got, at least this morning, which leads to a kind of, let's say, limitation or disappointment I would like to present you. If you expect, let's say, a further or complementary statement to my colleague from Austria, from the German perspective, I have to disappoint you, not only due to the fact that we in Germany, we are, I think, not so far with our legislation than you seem to be in Austria, but I would like to focus a little bit on an aspect related with security, or as our title indicates, insecurity, that should not be forgotten. And maybe it's a kind of, from my feeling, resume or, let's say, consequence from many of your statements you gave yesterday and today. And yeah, let me start with what I'd like to talk about, and maybe to narrow that down to additional perspective. When we talk about security or insecurity and the challenge how to secure European values, we have to think a little bit about what is security or what is insecurity, and especially what are values we are talking about or we are thinking always about. Whenever we think about or we discuss about our today topic, the terminology should not be, let's say, lost out of sight. Security might be seen as a kind of objectively understood term where we describe a kind of situation, a state of art, or state of a situation where there is a kind of threat to something that is called security, cyber security, attacks, hacking, or other technically driven threats against that what we all seem to be the normal state, or that what we like to have as a kind of security. The second interpretation of security is a highly subjective one. It's the question, how do we feel secure? Or while preparing my statement, I thought about how are we feeling well in our daily life, in our situation, not only as individuals, but as a society or a state as well. So let me focus a little bit on that. Not to forget, values I will talk about in some minutes, but not at the beginning. So within our conference, we practice a kind of multi-level perspective that aims at understanding the actual setting and developing a perspective to cope with technical, political, sociological, and economical challenges by legal means. That's my own profession. Yeah? So I'm always thinking about rules and the rule of law. So that's my professional defect. So please forgive me for that. Now, which security issues are we talking about? So the first issue might be seen as security understood as a situation where threats against information security, like hacking, other acts of cybercrime, are committed. And I include, let's say, the question my colleague already talked about a little bit under that aspect of security. If we look at the most recent activities of a European legislator, it seems that, for example, the Cyber Resilience Act, as well as the NIS2 directive, address these interpretations of security. But they do not only address security understood as a mainly technical aspect. They do address as well an interpretation of security as, think of yesterday, the resilience of a political society against manipulative attempts and threats against fundamental structures and principles of a pluralistic and democratic society. Yeah? So if we take this into account and we look at other legislative acts like, for example, the General Data Protection Regulation, Digital Markets Act, Digital Services Act, or Data Act, a further meaning of security, or better insecurity, becomes visible. All these acts, although they are addressing protecting of personal data and so on, they are addressing something like trust. Trust in the functioning of a competitive market, Digital Markets Act, where different chances of business opportunities might be taken and compete with each other in favor of a well-developing market and a well-developing economy. Trust in the rule of law. Yeah? Many of us are dedicated our business life to the belief that the rule of law is something we should protect. And the trust in the rule of law in the sense that the regulatory framework for everybody is to be respected by everybody. And that the enforcement of rules should be done without any willful and unjustified differentiation. Something we might get reminded when reading the newspapers or listening to the news these days. The third aspect of trust, trust in the effectiveness of the protection of human rights, specifically human dignity, and the right for self-determination of the individual. This is maybe something that touches what you call the conflict or the discrepancy between two different aims, constitutional aims, a state or an executive body has to follow. Last but not least, another trust, an aspect of trust, trust in a legal framework that is set up to serve the whole society and not only following individual particularistic interests. So we are all serving as legal professionals the society and not one or two groups or special groups of a society. For all this, and I'm quite aware that there are many other different aspects how security or insecurity might be interpreted. We talked about some of them in the last days. We have to be aware that within the upcoming digital society, the reach for security is nothing than abstract or artificial. It has to do something with our daily life. And this leads me to the second big interpretation of security, meaning the subjective factor. If people do not feel security as a kind of, as I said, well-being, their trust in the functionability of procedures, in the rectification of the rule of law, and in the end, in the reasoning of democracy as an ongoing process of self-determination will decrease or get lost. So trust will get lost if we do not feel well within our own surrounding, not only here at the Wolfgangsee. Nowadays, we all are witnessing how fast the erosion might take place. Now let's ask the crucial question, the real crucial question. How could we overcome all the threats, or at least most of them, against security or an increasing sentiment of insecurity? The title of our session is already giving us a kind of hint, European values. So, geniusly chosen topic, I think. But what does it mean? To be honest, the term European values sounds popular, sounds impressive, but I think it's quite hard to fill that up with a meaning that allows us to do something. But which values do we think, and what consequences do they have? From, let's say, a more political view or perspective, the answer might sound quite easy. Liberty, equality, and fraternity. Okay, since more than 250 years, a good guidance for our political, let's say, practice, but what are the consequences? So let me focus a little bit more on values I think are necessary and essential to deal with our struggle for regarding or reducing the feeling of insecurity. Maybe these values do not sound as impressive or typical like the French Revolution ones, but maybe they help us a little bit in guiding, getting some guidance. My first value is respect. I'm convinced that Immanuel Kant and his philosophical roots was right as he or they identified the human being as granted with the ability for reasoning and to direct its decisions and activities in accordance with fundamental values, again that term, that go beyond pure particularistic advantages and the fulfillment of basic needs just to survive. Yeah? They do not deny that. Yeah? It's necessary to survive, to act in accordance with values. But in addition to that, a very specific aspect of respect is the claim for transparency. Yeah? So we talked this morning about transparency, or you asked, I think, about the transparency this morning. And this is, my understanding, an aspect, a subcategory of respect as well. You only take your neighbor for serious if you do allow him to follow your own process, and your process of, let's say, setting your own mind. That's important, yeah, just to follow your thoughts, and the way how you are following a decision-making process. And this leads me to the second value. Take responsibility, or more generally, being responsible for something. Responsibility is to be understood as the ability to rectify decisions as well as activities on the basis of fundamental principles, of your own, my own principles that do guide me in decision-making, in acting, in doing something. This requires that decision makers, and we learned that many of us here are belonging to that small group of decision-making people. Decision makers are asked to stand for being questioned and giving answers to questions. That's what we impressively learned these days. Honesty is the positive side of responsibility. Neglecting the truth or claiming for alternative facts is the opposite. And I think this is something specifically as scientists we have to keep in mind very, very strictly. We are asked to stick to something that might be called truth, but if not truth, we have to stick to facts and nothing more and nothing less. Standing for responsibility does mean that one has to accept consequences that are induced by one's own decisions. And that leads me to the third value. Don't be afraid, I've only 3 to present you. The third is be credible, and trustworthy. As I mentioned already, in my opinion, the feeling for security or insecurity is deeply connected with trust. Respecting each other as human beings that are born to understand and to use our own given brain, taking responsibility for our decisions and actions and seeking for credibility might help us to rebuild lost trust or to strengthen existing trust. Trust in the rule of law, from my opinion. And now, to come to the end, what are the consequences for us as lawmakers, practitioners, politicians, officers, if you don't like to get the badge politician, but I doubt that is really correct, and business leaders. What are the consequences for us all? First, explain what you are doing. Be responsible for that, what you are doing, and explain it precisely or as clear as possible. Second, that's mainly a consequence for us dealing with law. Show the path through the supposedly identified jungle of complex legal framework. An impressive example we already had by you. Thank you for that clear explanation of maybe complex legal situation. And not only explaining that or leading through the jungle, please do give reasons for being like it is. People need to be taken serious. And by taking them serious, they ask for a reason for something. And the reason is not, it is like it is, full point, full stop. The third consequence, take everybody as serious as you like to be seen by yourself. That's quite easy. Yeah. If you like to be handled like an adult, behave like an adult. Yeah, so this is something, if you have children, it's a good advice, but it's a hard advice, so believe me. The fourth one, let your deeds follow your words. So I think the say of the United Nations is deeds, not words. So I would expand that a little bit, deeds and words, and they have both to fit together. And the last one, and that's my last remark, please, and that's addressed to all of us, please think before you act. Thank you very much.
Yeah, thank you. Thank you very much. While we are arranging the PowerPoint presentation, I'd like to introduce Nikolaus Forgó, who studied law, philosophy, and linguistics in Vienna and Paris before he served as University assistant at the Institute of Roman Law. He then became a professor of IT law and legal informatics at Leibniz University in Hanover. He is successfully running an LLM program on information and media law, and since 2017 he is professor of IT and intellectual property law, as well as head of the Department of Innovation and Digitalization of the University of Vienna. So now the floor is yours.
Thank you very much. I need to apologize for two reasons. The first one is I will stand somewhere here because I want to see my slides. I don't remember all of them. I hope that you can, in particular, Gary at the camera will be able to fix this. And the second reason why I need to apologize is that I think I heard the two presentations, and in my view, they were of a rather good mood and rather optimistic somehow. This will be a very pessimistic and very negative presentation, so sorry to ruin your lunch somehow. And I would start with a very simple question, somehow a very philosophical and fundamental question, which is, in a monarchy, imagine you live in a monarchy, and imagine that suddenly the sovereign, the king, the queen, becomes seriously ill. That is something that we saw quite often in history. And typically, one of the consequences of this is that people start to be afraid. It's uncertain what's going to come, and things might change. And that's not really a pleasant feeling. And therefore, normally, the sovereign, the king, the queen, tries to take some kind of counteraction against this, right? And this is what we saw quite recently in the United Kingdom. Some of you, those of you reading those fancy journalists might be, or looking on Instagram might be more aware than others here, that Princess Kate became seriously ill a few years ago. She was diagnosed with cancer. And one of the consequences of this cancer disease was that she got off the public for several weeks or even months, so people couldn't see her. People knew that she was seriously sick, but didn't really know what's going on. And as I said, this is a typical sign or a typical situation where people start being uncertain or afraid. So what do you do then as one part of the sovereignty? You start to take countermeasures somehow, and this is exactly what Princess Kate did, right? So this is a Twitter post or X post from Princess Kate from the 10th of March 2024, ages ago, 2024. We are living in a completely different world today. So this is from 2024, and that is what she posted on Twitter. So a typical family picture, her and her 3 children smiling, wishing everyone a nice day and nice festivities, and a very, I would say, nice image if you are concerned about that person. The problem with this picture now, however, is that if you look into the picture with some detail or interest into the details, and some people started to look into this picture quite quickly, it turns out that a lot in this picture is not authentic, that a lot on this picture is somehow manipulated, and that a lot of this is somehow manipulated probably using some kind of artificial intelligence, which is probably exactly not what you want to have if you are part of the sovereignty, because of course, people start to be even more concerned, right? So what do you do then in such a situation? Princess Kate did something very interesting. She took the official account of the Prince and the Princess of Wales on X, and she posted on X the statement that, like many amateur photographers, I do occasionally experiment with editing. I wanted to express my apologies, blah, 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 that people might be irritated. So question to the audience, who believes that Princess Kate is an amateur photographer using artificial intelligence to edit such a picture? Okay, you got it. That is unfortunate, and the situation becomes even more complicated then. So you probably need to escalate the situation by getting into a next step. And the next step in this case was another official social media account of the Prince and Princess of Wales. In this case, it was YouTube. And what Princess Kate then did was that she put a YouTube video with her speaking to the audience on YouTube. The problem now with this picture here is, if you look into it a little bit in detail, you find some funny, interesting details here. One of them being that the space here is larger than here. And if you look very, very closely, you even see one of her hair disappearing during the video. You can watch it after if you want. So there's one tiny hair that is there at the beginning, it's not there at the end. And there is this issue that this is much smaller here. The space here is much larger here than here. So what's the consequence of this? Obviously, people again start claiming that this is also AI-driven. The poster here clearly states that. Again, the argument is this is not authentic. It's not her. She's terminally ill. She's at home. She's not able to make a video in front of everybody. And then something interesting happens, because this post then, that this is fake, was put into context by one of those comments given on, or being possible to be given on Twitter. In this case, the comment was given by a user here stating that the video is authentic and taken by the BBC, because the BBC, the public broadcaster of the UK, argued that they were there and that they had taken the video. The problem now, of course, is if BBC takes the video and at the same time is the source explaining that the video is authentic, this is most likely a proper argument for you and me, not believing that the Earth is flat or something like this, or COVID is just an imagination. But it's possibly not helping against people who are not of this opinion. In the aftermath of this event, it then turned out that it might be, again, it's the BBC, by the way, reporting on this, right? So again, one of the parties in the game. It might be that those rumors that this is not authentic were given by some sources related to Russian intelligence services. This was in 2024. In 2025, a little bit later, things look like this. This is also rather well-known. Alex Jones, one rather well-known conspiracy theorist from the US, started to share a video showing Macron and others in a train. And this is a video, it's not an image, right? It's a video. And the claim that I will introduce to you in a second was shared by about 30 million people within a few days, 25,000 follow-up shares of this video, 8,000 comments, millions of people being affected. And the author of this, as I said, one of the major sources of this, is Alex Jones, who is, as I said, one of the main conspiracy theorists in the US. This is how his website looks today. I tend to be procrastinating when preparing such presentations, so this is from today in the morning. This is what you see when you look at Alex Jones, right? And the theory in this video is that you don't see three politicians negotiating what's going to happen in Ukraine. The theory you see here presented is that they are taking cocaine together, that all three of them are drug addicts, right? And that what they are doing here is that they just follow up to Zelensky, who is just another drug addict, in sharing cocaine in this train. If you zoom a little bit more into the picture, you see that it's a tissue, obviously, and not cocaine that is on the plate, on the table. But that explanation is now shared only by 60,000 people, not 300 million or whatever the other one was. And this rumor is important enough, just like with Kate, that institutions like the Tagesschau, which is the main public broadcaster in Germany, see the need to report on this, that obviously Macron and Merz and others are not taking drugs together and being filmed in this, right? Again, in 2025, you might remember that there was a power outage in Spain and in Portugal, a major power outage, serious security incident, very, very important. And it didn't take long that the ENISA, which is the European Network Information Security Agency, I repeat, the European Network Information Security Agency, the European body being in charge of security affairs in Europe, saw the need to explain that it was not, as they stated here, ENISA's name is not somehow part of this attack, right? So that it's not the official body being somehow involved in this, because just a few hours after this started, sorry, I was not clear that Russia was not part of the attack, because just a few hours after the attack, there were tweets tweeted like this, that the power outage in Spain and Portugal was part of a Russian attack undertaken by Russian hackers. And again, just to remember, ENISA needed to put on their website, on the very first page, it's not Russia doing this, and there is no probability that this is an act of war. Many here in the room are Austrians, right? So many of you might think now, okay, this is not really about us. We don't have a king or a queen, and we are not in a war situation, and there was no power outage. Unfortunately, no longer true, because this is the website of the Austrian National Bank, the ÖNB, from June of this year, where the Austrian National Bank sees the need to explain that their head doesn't make advertisements for some kind of crazy crypto coins that you can buy on the internet, right? So this is, again, this is the National Bank, and it's the official website on page 1 of the website, indicating we don't make advertisements for crypto coins you can get rid of. And other examples, this is an example from TikTok. This is somebody who just put a short video on TikTok claiming that Austria was somehow, as it's stated here, under attack, right? And what you see here, of course, is just a burning house somewhere. But again, thousands, hundred thousands, billions perhaps of people sharing a video where you might think, if you're not really properly informed, that Austria is somehow attacked. And I want also, because I think Markus was so optimistic about science and the role of scientists, I want to put a little bit of water into this wine by sharing with you my most recent personal story on this matter. And this personal story has something to do with the ongoing election of one of the seats in the in the German Constitutional Court. Germany needs to replace two seats in the Constitutional Court. And one of the candidates is this person here. She is a candidate from who was presented by the Social Democrats, and there was some kind of prior agreement on her informally in the coalition before she was publicly presented. And she is an academic. This is the correlation now. She's an academic by profession. She's a professor of law. And she's a former colleague of mine in Hanover. So I very closely collaborated with her, Frauke Brosius-Gersdorf, for several years. So this is somehow very close to my own field, because what happened to her, the German speakers in the room might know that she was not elected. And one of the reasons why she was not elected was that there was some kind of campaign ongoing. And this guy here is one of the leaders probably of this campaign, Julian Reichelt. He is the editor-in-chief of a publication called News, and this is one of those new propaganda instruments to be used in particular in Germany. And what does that have to do with me? Well, I'm one of the authors of a declaration of more than 300 professors of law making a public statement that you can't treat Frauke Brosius-Gersdorf in particular and academics of constitutional law in general in the way she was treated. So I was one of the authors of this. And what I also did, and that's the interesting part now, was that I did an interview in my podcast with the 3 leading authors of this declaration. So I interviewed all 3 of them. I know all 3 of them personally. And you can find that on YouTube if you're interested in it. I would highly recommend it, by the way. And what then happened to this video, and again, this is it's me, so not really important. It's a few hundred viewers watching this. It's not really significant. Nobody really is interested in this. It's highly academic, not really important. What happened to this, however, was that just a few hours after I published this, I received several comments, or we received several comments on this video. And these are the comments. One of them stating, this is not really relevant. A second one stating, she gets what she deserves. And there is a third one. This is the one I will look into a little bit more in detail in a second. But at the moment, just let me emphasize that all 3 of them are coming from some kind of pseudonymous account you don't really find anything about. If you really do a search on that person on the internet, you won't find anything. So you have three comments, one of them being a link. And if you follow the link, this is where you are led to, right? This is the website. It's called Infrarot Sicht ins Dunkel. And it's a guy in black and white image ranting about 15 minutes long about those 300 academics not really understanding the will of the people and blah, blah. So it's 15 minutes ranting against this interview, and in particular against the declaration that was signed by so many. And if you then start to search about this channel, this is what you find in FAZ, right? This is another somehow Russian-driven call it information channel or whatever. And the guy doing this in his spare time interviews people from AfD and other right-wing extremists on this channel. And I think this needs to be put into context into what Brigadier Sandner told us 2 days ago, that we are already in a situation of war, and that information is a key instrument of this war, because information is one of the strategic instruments to achieve a given goal, which is probably destabilizing Europe further. So that was the first part of this presentation, because the question obviously to be asked now is what to do, and what to do from a lawyer's perspective. And I think this was already negative, I'm sorry. The second part will be worse. So the second part starts with this, right? So when you again look into ENISA, the ENISA was already publishing in 2023 a paper that one of the most serious risks of Europe in 2023 when it comes to security was that the elections to the European Parliament might be manipulated. And since then, they really did their work, and they are very intensely analyzing the security situation in Europe, doing, for example, this overview on 2024, which is, in my view, a very interesting graph. So you should really look into this, because it gives you some kind of indication about where the ENISA sees different sectors in Europe. On the one hand, when it comes to the criticality of security incidents, and on the other hand, when it comes to the maturity of measures to be taken. And there are three up here which are very good because they are very critical, and at the same time they are very mature in taking action. It's telecom, electricity, and banking. No wonder, I would say, because those people have been doing this now for quite some time on a very professional level. And there's one that I'm very concerned about. This is my topic here, which is somehow not really performing very well. That's the public administration sector. Public administration is relatively critical, but not ready, period. Okay, this is the statement, and it's not me, it's ENISA stating this. In particular on the public administration, they say it's still in the early days of developing cybersecurity, lacking the support, experience, blah. It should aim to strengthen its cybersecurity capabilities. So people from public sector speaking about security in the domain are coming from a weak point, exclamation mark, right? This is not the sector you would look into if you want to get proper information about security. One other statement here from them is the public administration sector is among the least mature sectors, newly regulated under the NIS 2 directive. The sector is still very much in the early stages of aligning with its requirements and lacks the well-established support and experience seen in more mature sectors. This is not me speaking, it's ENISA, right? And they are referring to one piece of legislation here, which is NIS 2, Network Information Security 2. Question to the lawyers in the room, until when would that have been to be transposed in Austria? October 2024, exclamation mark again. This was due in October 2024, not yet part of the Austrian law, neither of the German law, by the way. Same thing in Germany. So my diagnosis of this is the public sector, this is now me, this is not ENISA, the public sector is constantly trying to regulate security in a situation of war without proper expertise in the field and constantly exempting himself. That's also one thing that they always do. But everyone is regulated, not the public sector. And that produces, and I'm almost done, a very uncomfortable situation of fear, as I say, and I'm feeling this very much. I think you can feel that I'm feeling this. And that, in the legal part, it produces some kind of magic law. We have that's another point I would really like you to discuss, if you want. I think we have no longer the situation that the legislator produces something which looks like a law. It's more like magical rituals that we are in when it comes to this field. And without going into any detail here, this is just a list of those parts of the magical ritual in which we are. Each of those acronyms stands for about 150 pages as an average of legal text, all of them trying to regulate somehow the digital. And the new commission, so the von der Leyen II commission, has not stopped this. On the contrary, when you read what von der Leyen is proposing in her political program in July 2024, I'm probably one of the very few people having enough free time during the day to read these documents. So when you look into this first statement that you read there is, Europe needs a data revolution. That's now von der Leyen speaking, which is very bizarre in my view, because last time I checked, revolutions were instruments where the people wanted to replace the government. In this case, it's the government telling the people what they need to do. And then she says, this is now literally von der Leyen, this is why we will put forward, so this is the start, Europe needs a data revolution. Next sentence, this is why we will put forward a European data union strategy. This will draw on existing data rules to ensure a simplified, clear and coherent legal framework. Who in the room sees the existing framework as being simple, clear and coherent? Okay. For businesses and administrations to share data seamlessly and at scale while respecting high privacy and security standards. Europe will come up to a simplified, clear, and coherent legal framework. I would need another 20 hours to go into details here, but let me just stress one point here, just as a very stupid example about the coherence. And let me test the coherence with one very stupid, as I said, very simple, easily understandable example. And the example is, I try to answer the question, how high are the maximum fines if you breach one of those laws? Okay, so what is the maximum risk? And we compare 4 of them: GDPR, DSA, NIS2, and Cyber Resilience Act. Right? In GDPR, it's up to 4%, and the wording is also important, by the way, because the wording is also different. Right? In GDPR, it's up to 4% of blah, blah, blah. In DSA, it's not exceeding 6%. In NIS2, it's not a figure because this is a directive that would have needed to be transposed into national law. And in Cyber Resilience Act, I like this in particular, it's 2.5%, right? So people probably couldn't agree on whether it should be 2 or 3. So they took 2.5. Obviously, one might ask the question, why is this? Why is it? And why is it that an infringement of DSA costs you up to 4%? 6%. An infringement of GDPR costs you up to 4%. An infringement of CRA costs you just 2.5%. Is there any substantial reason for this? And that's probably a too specific question, because if you read the CRA, you see that even the wording here, so this is the original, so I want to share this with you so that you believe me. Even the wording is not correct in the way, right? It says up to 2.5% of its total worldwide. Okay? So I'm a little bit speechless here, and let me just close, therefore, with one important slide. This is again me speaking. Lawyers and the way we make law and the way we make lawyers making their careers are part of the problem and not of the solution. Thank you.
Yeah, you kept your promise that you will bring a rather negative perspective on the topics to discuss. Personally, I was looking for at least a positive aspect, and maybe it's the awareness of how privileged I am not to be the Princess of Wales or a public figure. So we have the chance to drop out from social media if we want to, but all the other problems you raised are still very concerning. I would like to initially ask the panelists whether you would like to ask or to comment on the presentation of the other panelists. Is there any interest in commenting each other?
Quite a short comment, because there might arise some doubts that I'm too optimistic. Maybe I talked in the wrong way. Strengthening or stressing on the fact that we should think before we act is very pessimistic statement, because that's lacking today. And I would agree in your finding that lawyers are part of the problem, not of the solution. But the crucial question is for me, how should we overcome this situation? And I'm afraid that you're identifying quite well that we are already part of a kind of, let's say, information war. It's maybe the wording is not precise enough, but we're in a situation where conflicts are exercised mainly by manipulating information and the public awareness of what's going on in the society. And I personally have no idea how otherwise than only, let's say, motivating people to go forward and to stand for what they like to be in future, than only engaging themselves. So I would slightly oppose with a negative touch that might lead me to, well, okay, resignation, it doesn't matter at all. So that's a new understanding of resilience. It's not worth to do anything. I think that would be the wrong way.
Would you like to respond, or shall we? Okay, so we continue with the public debate. Well, the sky is not the limit, but the lunch break is. So we have more or less 35 to 40 minutes. And I would prefer to collect several questions and then have a common response to the questions. So please raise your hands. And please shortly introduce yourself and then let us know whom you're going to address. Please.